shareholders agreement is a document not required by law, but so strongly recommended by any corporate counsel. Shareholders agreement sets out the rights, roles, and responsibilities of each shareholder party, without which there are no rules of the game. And a lot of terrible things can happen. And I'll give you a few examples to give color to that statement. Say you have a business that's owned by two individuals. Let's say the business is a restaurant and the business is run through a corporation. So you have two shareholders, you have no shareholders agreement. One day, one of the partners decides that they don't want to come in and work for the restaurant anymore. What happens? Well, without a shareholders agreement, nothing. The remaining shareholder is now in business for the exiting shareholder, because as long as you're a shareholder, it means you have a right to receive the distribution of profit on an annual basis proportionate to your shareholdings. So you own 50% of the share capital of a corporation, you're going to receive 50% of the profit. There's no obligation to actually work for the business. And a lot of people, I guess, don't know this initially. And so we get calls all the time saying, oh my goodness, what am I going to do? My partner says, I don't want to come to work anymore, and you have it. And I say, well, unfortunately, if there's no shareholders agreement, there's nothing that we can do by law to force that individual to work for the company, because there's no requirement that they work for the company as a shareholder. And so now you're in business for this other guy, because you're coming to work every day and you're working your ass off and you have to split profits 50-50. So shareholders agreement. If you had a shareholders agreement in place, it would set out what are the rights, what are the rules and responsibilities of each party, and what happens if they don't keep to those rules and they don't show up for work. Well, maybe there's a redemption of shares, maybe there's a forced share transfer. So there's mechanisms in place to address that kind of situation. Another situation that we see often is, let's say in my example, we have a two shareholder corporation. So we have two partners that run their business through a shareholder, and one or both of them are older and one wants to retire. And so one turns to the other and says, hey, I want to retire, I want to sell my shares. Okay. One guy says, the exiting shareholder says, I want to sell my shares to you. I think that the company's worth $1 million, so I'm going to sell my shares to you for $500,000. And the other shareholder says, no. Or I think they're worth $30,000. Then what do? The shareholder trying to exit has no mechanism to exit. They are stuck with their shares, and we've seen this, and it's really unfortunate. The shareholder trying to exit has no mechanism to force the other shareholder to buy him out at any reasonable valuation. And so the options are negotiate with your partner and agree on a price, and the partner's going to say, well, I think it's worth 30 grand, even though it's not. And you're kind of in their hands if you want to be able to exit the company. Or you sell the shares on the open market. So you would have to find someone else who wants to buy in to this business, and then you can sell the shares for whatever it is that you agree with this third party. If you had a shareholders agreement, there would be a mechanism here. There would be typically a mechanism maybe called a shotgun clause, which is a pretty standard covenant that would require the other party to buy you out if triggered in a certain way without getting into it. There are other put and call rights or piggybacks or drag along clauses that otherwise force a shareholder to sell their shares under certain circumstances or buy shares under other circumstances. But basically there's terminology that's built that would alleviate the situation. So without a shareholders agreement, there's no rules to the game. There's no methods of valuation, which is something that parties fight about all the time. Even take out the scenario of the retiring shareholder. Any shareholder, they want to exit the company. They say, okay, I'd like to move on. I'd like to sell my shares. Now you have issues as to valuation. So the shareholders agreement would already have a mechanism in which the shares are valued in advance. A shareholders agreement would also address something called family law rights or Family Law Act rights. Another nightmare scenario, so you're in business with your partner is married, your partner goes through some marital trouble, and now your partner's filed for divorce. The shares of your corporation form part of the equalization of net family property in that divorce. And so now the shares are lost to the spouse, and now you're not in business with your partner anymore, you're in business with your partner's ex-spouse who might know nothing about how to run that business, but hey, you have to profit share with them, and now you're in business for them. And so a key provision is the Family Law Act provision, which would basically prevent that from happening. There are other key provisions regarding death, divorce, disability. Divorce I already spoke of, but death or disability, so similar situation, if a shareholder dies or becomes disabled, there should be a mechanism in which you can claw back those individual shares. Otherwise, you're now working for the estate of your deceased partner. And now don't think that those provisions are crass, because in those circumstances what happens is that the family of that deceased or disabled shareholder receives a true valuation of those shares, but that individual is no longer a shareholder. So you're not taking anything away from their family. It's just a mechanism to pay them out what they're rightfully owed, and then you assume full carriage and control over the corporation. Otherwise, you're stuck with, let's say, a power of attorney for your incapacitated partner, and now again you're in business with your partner's spouse. Or your partner otherwise cannot contribute to the business because they're incapacitated, and you have to profit split with them, which is not a situation that you want. And so there are so many scenarios, there's so many reasons why you want a shareholders agreement. A shareholders agreement will set out all of these things and more. And I always say it's a roadmap, it's rules of the game. It's not meant to become a contentious point at the outset. It really does avoid disputes if you get one in place early on, because every scenario has already been thought out and there's a mechanism for resolve of that scenario, rather than dealing with it when it comes up, which will inevitably turn to a dispute. And so that's the reason why lawyers so strongly recommend a shareholders agreement. And so if you don't have a shareholders agreement and you are in business with a partner, give us a call, talk to us. We can see what we can do and how we can layer in a shareholders agreement into your corporate governance documents.